Hi, everybody, and welcome. We're just going to give another minute for people to get settled. And then we're going to start this very interesting community conversation. All right, I want to be cognizant of everyone's time. So welcome, everyone. Thank you for joining us for this community conversation. Social workers and sexual misconduct claims, sponsored by our friends at ASI. Just a couple of housekeeping items before we start. When you signed up for this webinar, you agreed to a code of conduct. What that means is we expect you to be respectful to each other and to the presenters, which I know you will be. You know, this is or can be a very sensitive subject. So when you ask questions or are making comments, please don't share personal details. You can ask questions in the chat. The presenters really encourage a dialogue, so please don't hesitate, or you can raise your little yellow hand. The presenters are going to take questions as we go along. If they don't know the answer or they're not sure, they've assured me that they will get back to people once they've researched the question. We're really lucky. We've got the dream team here. We've got Dina, Lonnie, and Phil from Risk Management at ASI and another company. And this is what they do all day long. So we're really happy that you could join us, and we thank you for your time. And Lonnie, if you want to put up your presentation.
Certainly. Let's see, here we go, and share. There we go. Can everybody see that okay? Okay. And Phil, do you want me to just have you open up by jumping to the first slide?
Yeah, that'd be good. Yeah.
There we go.
I hope it's the one that I have in front of me. Ah, there you go.
Hold on
Okay.
a second, previous. Boom.
Yeah.
Okay, that's all of us.
Yeah.
And just to actually, I'm going to take a moment to introduce everybody. Sorry. This is Phil Lawson, is Vice President of Product Development and Risk. He knows the ins and outs of claim situations. Dina Larson is our Senior Risk Analyst, Resolution Manager. She's with Gallagher Bassett, which is formerly known as an organization called Western Litigation. They work to handle our risk management hotline calls and also make sure that claims are allocated resources for your defense in our professional liability policies and other programs. I'm Lonnie Ropp. I'm Vice President of Underwriting and Distribution. I work for the NASW Risk Retention Group. And just so you know, the Risk Retention Group is actually just a liability insurance company. So that's specifically the focus of my occupation, but there's a lot of folks at NASW Assurance Services that do a lot of other things. So, but just wanted to set your expectation for who the crowd is today. And with that, I'm going to open up to Phil Lawson, who is going to share some information.
Yeah, thanks, Lonnie. Yeah, I'm glad you all could join us today. This is probably the most important subject, and that's why we put it as number one in the community conversations. It's sexual misconduct is it's not as frequent as our claims and claims losses are, but it's the most severe claim that we see. We've probably had maybe 10 or 15 of these in our 9 or 10 year history. But the highest claim was $860,000. So it's very, it's very severe. And I've bifurcated this into really two groups of sexual misconduct categories. One is where that's why I call it a two-headed monster. One of them is where the practitioner or the therapist deliberately does something, crosses a boundary, and causes a sexual misconduct claim. And the other was they indirectly do it. They don't even realize that they set the stage for that. And believe it or not, there's more of the indirect frequency of occurrences than there are direct sexual misconduct activities. So let me give you a few examples. I do want to share with you. I write the tip of the month every month for us. There's so far 99 articles that I've written over the past decade, I guess. And the one in November, you should take a look at. They're free. They're on the ASI site, and that's I think I call it sexual misconduct. Yeah, sometimes I make interesting titles, but this is just a sexual misconduct. And in there, I share 8 cases of direct and indirect boundary crossings and sexual misconduct claims that I've seen. And I'm going to refer to those, not in a lot of detail because it's already in the tip of the month, but I'll share with you in this brief discussion a few examples on each side of the equation. I guess let's start with the direct boundary crossing first. There was one case that we had where, it's typical where you had a physical approach by a psychologist who kissed and groped a patient in the office. So then he got sued. That also spilled over into an indirect situation where a witness to that event, who was an employee, didn't report it. We did not insure the psychologist, but we did ensure we had a policy in place with the witness, the employee there. And had she stepped up and reported that what she witnessed, there wouldn't have been a lawsuit against her. But because she didn't do that, she was included in the lawsuit. We defended her, and that was a pretty expensive claim. So that's one example of an indirect and a direct example of sexual misconduct. Another example of a direct sexual misconduct is we had a therapist who we insured who didn't do anything physical with the client. The client was a little unstable emotionally and mentally, and he sent a series of porn pictures and emails and letters and cards to her and stuff. So he got sued, and so we had to defend him. That's another example of direct. And then there was another one that was non-physical in nature, but it was a direct sexual misconduct, and it's based on language. A client came to the social worker's office on a pre-gastric bypass visit. She needed a little emotional support, and so he had a witness, he had an employee who was in, which is a good idea to have an employee with you when you're talking about these things. But he said some pretty outlandish things. He very objective, without any kind of empathy. He told her she was as big as the house and she was as big as Jabba the Hutt, and you just don't say things like that. So he got sued, and we're defending him now. That's a ongoing case. And now the turning to the direct boundary crossings, these are considerably more serious. We had one situation where we have a social worker, policyholder for professional liability, who had 2 clients. One client, the female, was an active client, and she had another client, a male, who had not been a client for over a year. And she wanted to go on vacation, and she had the male client use her car to drive her to the airport, and the female client, she hired her to be a house sitter. Well, first thing, you don't hire clients or ex-clients for anything. And so after he dropped the social worker off at the airport, he took her car back to the house as planned, and then he raped the female. So he's in prison. But there was a lot of legal defense there. We had to defend her. So that was a couple of lessons learned there. Is you not only do you have a boundary violation, you don't bring people into your house like that, and you don't hire people who are clients, and you don't expose your clients to that kind of risk. Another example, we had a contractor. If you have an agency, for example, or you work in an agency, there were two people that owned an agency. They were partners, and they hired a contractor to provide social work services to a minor child, and he had a great track record. No violations, no board inquiries, nothing, and really good background academically, good work history. And I don't know what happened, but there was child molestation involved, and he's in prison for 15 years. And now the lawsuit against our policyholders were co-owners of the agency, and we defended them. We had a good vicarious liability defense, but because there were issues with reporting and not reporting and poor documentation with respect to the contractor, we settled that case. We don't usually settle, but we had to. So that's an example. Is if you bring in contractors or outsiders or part-timers, stay on top of the cases and the documentation promptly. Don't let things fester. Just stay on top of that, because it would reduce your liability. So that's lesson number 2. Lesson number 1 is you don't hire clients to do anything. And even if they're ex-clients, it's best not to involve them with a work relationship or even a personal relationship. Another example I have, which was our largest case, the $860,000 case, was we had a social worker who did not do anything wrong in and of itself. She was working for a public school district and not an employee of the district, providing social work services. It was a rural public school, and there was a 13-year-old girl who was mentally challenged, and she needed additional therapy through the summer. And so the father really liked the way the social worker treated the girl, his daughter, and the school did too. So they arranged for our policyholder, the social worker, to provide services over the summer, which she did. But the problem was there wasn't any venue that she could go to other than her home office. So what she did was she had the girl, the patient, visit her in her home office, and she started to commingle her home life with the office, which you don't do, and took her out on field trips. And to make matters worse, her daughter and her daughter's boyfriend were living in the house, and the daughter's boyfriend took advantage, and he's serving 15 years in prison. And so she said she didn't intend for this to happen, but it's a consequence of a boundary violation where she didn't build the firewalls necessary in her home office. A lot of practitioners have home offices, but you have to make sure you build a firewall there and stick to it. And you don't bring non-therapy people on field trips or family members. If you're going to do a field trip with with a client, you keep it professionally. You just keep the professionals involved in that venue, even if it's at the zoo or a public park. You don't bring a family member in to join in. That's a boundary crossing as well, and it leads to bad things. And those are the key areas. So you'll see that sexual misconduct can arise. They all arise out of boundary violations, and occasionally they fester into pretty serious sexual misconduct claims. So another thing you want to look at in your policies, if whether or not you're buying a PLI policy from us, you want to check your policy to see, first of all, whether sexual misconduct is covered and to what extent. What's the sublimit on that? and also additional insurers and contractors. Are they actually covered for this peril? And keep in mind, you're always going to have a lawyer on the plaintiff side look for a way to bypass whatever the sublimits are. So they always go right for the negligence claim, and there's a whole wide array of related negligence claims, so they can get past the sexual misconduct anyway. So you just want to see your policy, what sort of exclusions exist if you're not covered under our policy. Our policy is the most comprehensive in the country, so you're well protected. Are there any questions on what I had mentioned?
Hey, Phil. I'm sorry, Helen, go ahead. Go ahead.
I was just going to say no questions yet, but Dina, please.
Okay, so Phil talked about the lawsuit claims, which is what he sees mostly. What I see are the licensing board complaints. I see, and I talked to a lot of social workers about these, and they range from a sexual relationship with a client or a former client to inadvertent comments to pictures hanging on the wall in your office. We've even seen a licensing board complaint based on a bumper sticker on the social worker's car in the parking lot, and people complaining about that. The biggest issue with these kind of complaints when they go to your state licensing board is that the licensing boards in this country, for the most part, have a zero tolerance for these kind of claims. If you've had a personal relationship with your client, whether it's a current client or a former client, odds are really good that you are going to lose your license, and you will lose the privilege you have to practice your craft. You worked really hard and really long, and you spent a lot of money getting to where you are. Don't assume that just because, well, you didn't mean any harm, that's not going to happen. I've spoken with a lot of social workers who said, well, I thought because I terminated services before we got involved that it would be okay. No, it's not okay. It's not. You need to know what the rules are in your state. There are some states that say never. There are some states that say they have to have not been your client for 5 years or 2 years or something. You need to know this, but be aware that the risk is there. If you get into that relationship, it could cause problems. We have had licensing board complaints filed by the ex-spouse of the client who got into the relationship with the social worker. Supposedly the ex-wife was okay with this relationship, and then she wasn't okay with the relationship. So you don't know when it's going to blow up in your face. Please, please, as Phil said, set those boundaries up front. Let your client know these are the rules. I tell social workers on the hotline all the time, have the my house, my rules conversation with your client. These are the boundaries. We don't cross them. I'm the therapist, you're the client. That's all it's ever going to be, because the risk is just too great. You can lose your license. That is no joke.
There are extenuating circumstances also, to piggyback on what Dina said, that we had one case where you had a husband and a wife and 3 children were all patients of a social worker, and there was a continuing sexual relationship between the social worker and the wife. And bear in mind, the social worker is treating the husband and the wife and the children. And what happens here when children are involved, it really increases your claim, because you have to set aside reserve money for the children until they reach majority age for their treatment and testing. So that's just a side thing. It's a bad idea to cross those boundary lines.
Yeah, the other boundary that you think might be harmless, and I've seen this come up several different times, is when the social worker is trying to help just wants to help out and winds up taking a client into their home. They're trying to get them out of a bad situation or a bad circumstance, and they feel the client would be safer in their home than where they are. Well, maybe so, but that's when you make the call to Child Protective Services. That's when you make the call to the police. It's not your job to put the client up somewhere. It's not your job to become the hotel, because I'm dealing with licensing board complaints right now where a social worker took a child in, and you wind up with, did you endanger the child more? Did you report it appropriately? Did you hurt, cause the child more damage? And when you deal with children, as the slide says, the claims and the damages absolutely astronomically climb.
Yeah, we had one with the 1998 when we had a different carrier involved. We're the carrier now, where the practitioner gave a hot dog to a 16-year-old client. I don't know the details, whether the social worker brought the child into the house or not, but the child choked to death on the hot dog, and there was a wrongful death suit, and it was $1 million settlement on that.
It's,
they're not hired to cook hot dogs. They're hired to provide social work services.
yes. Remember what your role is. That's the biggest thing. And the second bullet point on this slide talks about digital and telephonic communication channels. I've spoken with a lot of social workers who deal with teens. They treat teenagers, and they believe, because that's how most teens communicate by text message, that that's the best way to communicate with them. I would respectfully, very respectfully disagree, because you don't know who the person is on the other end of that phone. And an innocent conversation can be twisted so quickly and so easily into something that's suddenly inappropriate. All of a sudden, pictures are being exchanged. And that happens if you're on Skype or a Zoom call or FaceTime or whatever communication, whatever you're using for telehealth. It can skyrocket out of control so quickly. You need to set the boundaries. You need to hold on to them. Just hold tight. You have to do that. Protect yourself, protect your license.
Yeah, Dina, before we go to the question about the last bullet point, do we want to do the, like random question, correct or incorrect?
Yes.
Okay,
Great.
I saw a question come across the screen about what insurance are you, or something like that.
Yeah, I already answered it, Phil.
Oh,
Yeah.
okay.
I said NASW Risk Retention Group. It's the liability insurance program.
Yeah, okay.
Yeah. And I'm just going to briefly stop share because it's in a different place, and I will grab it. I have it ready to go.
Lonnie, it's Jeff. Do you want to drop the website also in the chat? I can do that. I don't know if you want me to do the risk retention website or the ASI website.
Go ahead and do the ASI website, because essentially all of our risk management resources are right there. So it's all set.
Got it. I'm going to put that in the chat right now.
All right, so let me pull this up, and I'm going to do, and this is, keep in mind, this is a question that if you choose not to respond, that's fine. If you would like to put in the chat whether it's correct or incorrect, that's fine. It's, no harm, no foul. It's just a really random question because we found that some folks have misunderstood it over time. Let's see, share. Sorry. So this is just to break it up a little bit. So the statement is, and this is a correct or incorrect. terminating the therapeutic relationship avoids adverse public licensing board outcomes. And when we use that term or that terminology, it's related to having a relationship with your client that otherwise typically would not be able to. So does terminating the relationship, is that a correct statement that, you know, nothing bad can happen, or would you suggest it's incorrect?
And should people answer in the chat? Oh, they are good.
Okay.
So put your answer in the chat.
Let's see.
Excellent. I'm seeing lots of incorrects, and that's absolutely correct. It is incorrect. Just because you terminate that professional relationship does not mean that you're not going to wind up with a licensing board complaint. That's basic. That's akin to closing the barn door after the horse is already gone. It's just, you need to keep the relationship with your clients on a professional level only. I have spoken with social workers who are extremely cautious using social media platforms. For example, Facebook, since I know we're broadcasting to Facebook, you need to be extremely careful with that, because you don't know, you may think you're commenting to a closed group, but each person in that closed group has friends, and those friends have friends, and it's, you know, throw the rock in the pond and watch the ripples go out. It's the same thing. You need to be careful.
Yeah, and I've seen circumstances where somebody felt as though, you know, I terminated the therapeutic relationship, so I was okay to have the type of relationship that they had with them. But it turns out, because what happened to that person was essentially they misunderstood that once termination took place, they thought it wasn't a situation where they had no time frame to consider. So, like, take for example, in the US, and Dina, you chime in on this. Every state's a little bit different. There are some states that allow you to have a relationship with a client after a certain period of time. And when we're talking about period of time, we're talking about like decades. Sometimes it's a decade, sometimes it's 7 years. It just depends on what state you live in. So when Dina was making the point about being, you know, intimate with and understanding the law, it's because, you know, a colleague could, you know, remember, hey, I remember the law saying that you could after a certain point. And if you never took the second step to look it up, it just poses a bad situation. So I just wanted to share that since the topic came up.
And Lonnie, also, it puts this, and this just reminds me of something else. It puts your colleagues in a difficult position as well. Because if you have a relationship with a client, current client, former client, whatever, and you terminate services with that client, if they still need services, they're going to go to another therapist. And if they're going to advance in their therapy, they're going to have to disclose this relationship, which is putting that second therapist in the position of, now they have to report you for having an inappropriate boundaries and inappropriate relationship with a client or a former client. So now you've got a colleague that has to report you. It gets very ugly very fast.
I'd probably add one thing, because, you know, we're talking about a very heavy subject, and the outcomes are challenging. But back to the purpose of our policy. The purpose of our policy is to position a defense for our policyholders, and that's what we will ardently do. So a lot of the examples we're using today are the folks that admittedly had a bad circumstance, and all of the discovery showed that it was pretty bad. For the most part, though, most allegations in this category actually are are unfounded. So there are some cases, many, if not most cases where allegations are made and through the defense provided, it's shown that it really was not what it was portrayed to be.
Yeah, no, correct.
And in those cases, our hard work, appropriately so, would result in a dismissal of all charges, which is exactly where you need to be, because a lot of times people make allegations for different motivations that have nothing to do with you. So keep that in mind. We're talking about a very heavy subject, and we're talking about circumstances that we've encountered. But on the flip side, I want to tell you the good story is, one, you're supported with a defense, and we are unrelenting in that regard related to client care. But the flip side is that most of these outcomes are dismissed, or they found that, you know, the charges were unfounded.
Yeah, right. 99% of the time, if they get past an incident to become a claim, they're dismissed. I would put you on notice that beware if you're counseling a couple involved with marital disputes or divorce. That's when things really get bad, and they're looking to throw mud at each other, and they'll pull the social worker in to the mud fight.
Yep, in a heartbeat they will, Phil. That's a very good point. And it's not just marital issues. Child custody is another one that's just horrific, because it ceases very, very quickly to be about the child and to be about the scrap between the couple that is fighting over the child, and they will take a swing at anybody that they think will accomplish their objective, and that's usually the social worker. They make all sorts of allegations against social workers, and desperate parents are not above making unfounded allegations that you are going to have to deal with. And as Lonnie very appropriately said, yes, this policy does provide a defense for that. We've got phenomenal attorneys that we work with across the country that are very experienced with all of this stuff. And they provide a great resource for these claims, and they will fight forever to show that you didn't do what you've been accused of doing. So
yeah, occasionally we find the professional litigator, and this could be beyond sexual misconduct, just for anything. These people know how to work the courts, and they just want to be a nuisance, hoping to get a settlement.
yes,
And we know who they are because you can see the docket from past cases. And there's a few of them out there that we're always tangling with.
We have a question that's come in from Elizabeth, if that's okay.
yes.
Elizabeth, do you want to come on mic and ask your question?
Good morning. Yes, well, good afternoon. I was just wondering, how soon should a person become insured? For example, I am an intern, MSW intern, so I'm not quite practicing yet. So
Lonnie, do you want to handle that one?
Sure. A lot of, so as an MSW intern, are you providing certain services within the scope of an MSW intern? Or you're helping people, right?
well, and not exactly. I do have the insurance that is required from schools.
Oh, sure. And that's going to
Right.
support you in that effort.
Right. As
So,
I
go ahead. Sorry.
as I reach, towards graduation, at what point should someone become insured?
Mhm. So anytime you are working either directly or indirectly, so when I use the term indirectly, there may be certain efforts that you can do only as a licensed practitioner, but it takes time to get there, right? And certain hours, and there's a lot of circumstances that you have to move toward. But there are some efforts that are within the scope of your current credential. And when that is the case, you're still providing what you can provide within your effort as an MSW. When you are working professionally, I do suggest the coverage even before licensure is a factor. Just because these kind of allegations can pop up regardless. And a lot of folks have actually asked, well, if I work for a company, they're going to provide my liability insurance. And certainly they will for their purposes of defending the entity and any employee in it. But keep in mind, and this just brings it back to the context of what we're talking about today. Sexual misconduct allegations is something that may be something that they have to report to appropriate authorities, whether even if it's a licensing board, even if you're not licensed, they can still report certain things. But in addition to, it's especially if it's severe enough, it can even be reported to other entities. So once they do that, the entity cannot afford you coverage because they had to report you. So that's why having your own policy in this circumstance, and I'm just giving this in the context of our discussion today, there are some, funding models that are associated with reporting certain actions on an external situation instead of handling as an internal matter, especially with the heavy implications of that. So I do suggest having it even before you get to a point where you think you should have it, because it's always good to have that extra protection.
I strongly advocate that, Elizabeth, and here's why. As an intern, when you're in the theater, you're liable. Even if you're not providing treatment, you're liable. And, if I was you, and I'd probably consider a claims made, your PLI policy, 1 million, 3 million, your first year premium might be $55 or something like that. That's a drop in the bucket compared with the liability you'd face. If you want lifetime coverage for that period, then consider an occurrence policy, and that's about $2.25 per year. So it's still pretty cheap. So that's what I'd do.
Thank you.
Yeah, Elizabeth, those are great comments. What I have seen, I'm a paralegal by profession. I'm not a social worker, but I've been at this for 30 some odd years. And I have seen over the course of that time that people will make a claim against anybody they can.
Yep.
Anybody who comes into their range. And you can have little to no involvement in a situation, but you're winding up defending yourself because you can't not.
You have to have a lawyer. You have to have a lawyer to file a dismissal, and that costs a lot of money.
And if you've got insurance, if you've got a professional liability insurance policy, obviously coverage needs to be confirmed, but if you were working in the scope of your practice and you were doing what you should and you didn't do anything wrong, your policy should cover you. Your policy should provide a defense, and then your policy pays for that attorney. And
yeah, if you don't have it, and we have a zero deductible also, but if you don't have a policy and you get pulled into a complaint as a defendant, you got to hire a lawyer. If you don't have a policy, you got to hire a lawyer to file for that dismissal, and you're looking at $400 to $800 an hour, depending on who you hire. That's a whole lot more than premium for the year.
Yeah, a lot of money. So it's a little bit of outlay for a whole lot of comfort at night.
Yeah.
Mm-hmm. Lonnie, do we have another of those questions?
I do. They are on a big, let me go ahead and pull it up. They're on a big list, so let me see if I can segregate it. Just one second. Okay. You can do quick editing because we already answered that one. That's not going to work with me. I'll just delete that. That works.
Or if that won't work, Lonnie, just read the question. That'll work.
Okay. You're sure no one will find out? Correct would be it's okay to go ahead and have a relationship with a client. Incorrect would mean that no, you should not. You're sure nobody will find out.
So the premise is you are convinced that no one's ever going to find out that you are having a relationship with a current or former client. Is that correct or incorrect?
Mhm.
And the answers that I'm seeing are spot on. It is incorrect. You guys all know this. You all know this stuff. Nobody can keep a secret. That's why you have a job. You're going to tell somebody, you know, that the former client is going to tell somebody. It's going to be innocent. And they say, you know, the former client that you're now in a relationship says, oh, I promise I won't tell anybody, but I had to tell my very best friend and I swore her to secrecy. No, no, it's not going to stay a secret.
Mhm.
It's not.
I'm going to throw up two really quick. I'm going to do a share screen on this. I just clipped it. Hold on, copy. Here. There's two here, and I'm just going to apologize in advance. Navigating. Here we go. All right, there's two statements here. And it actually refers back to the code of conduct. And I've seen this used. So essentially this one at the top right here, this is the one we want to work with. So the activity can be justified because the professional has a personal belief they can prove their client is not adversely affected, as mentioned in the NASW Code of Ethics in 1.09C. And actually, for our purposes, here's 1.09C from the NASW Code of Ethics. So, and just referring to that, and can everybody see my screen?
Yeah.
Okay.
You draw well, Lonnie. You draw very well.
Okay. So this is going to be the question. Is this correct? I can go forward because I can prove beyond a reasonable doubt that I know my client's not going to be adversely affected. So I can go ahead and move ahead. Correct would be the answer if I agree with that statement. Incorrect is if I don't agree with that statement. And right now I can't see the chat. So if anybody has anything in there, Dina, maybe you can take a look at that for me.
The answers are coming up. They're all agreeing that this is incorrect.
Okay, perfect.
Yeah, if you look at section 1.09C, you will see down towards the bottom that it is your responsibility. You are going to have to prove that this former client hasn't been exploited, coerced, or manipulated. And just because the relationship is good now, you guys are in this business. You know that relationships go bad. You know this. And just because everything is all sunshine and daisies right now, doesn't mean it's going to stay that way. And if you've got a client who you have a falling out with, you got into this relationship and now you've fallen out, if they're mad enough, they're going to turn you in. They're going to file a claim. They're going to do something. It's not going to end well.
Yeah, I had somebody tell me that one time. And I knew about that. But the circumstances were, you know, way out there in comparison. And I said, well, let me know how it works out and then come back to me afterward. And why would I be taking up this topic? I'm actually in underwriting. So my job as an underwriter is to look at a risk, each and every risk, and it's and predict future outcomes. And so just so you know, one of the most troubling, predictions of the future is having admitted circumstances or circumstances relating to sexual misconduct that are compelling to show that it actually took place. I can't tell you whether the client was exploited or not. I wasn't, I won't even try to do that. But my job is to say, well, just predicting this based on a future risk, I have to see what the outcome is. And if the licensing board didn't see that circumstance the way that the person believed that they would come out based on an interpretation of the code, I have to let you know that if it doesn't go in your favor in the end, even though all hopes are that that's the case, it puts me in a position where I have to potentially non-renew the policy. And what happens in a non-renewal? At the next expiration date, I would not be able to offer a new policy, and those type of circumstances that end up poor. I'm not talking about the ones that are dismissed, but the ones that show a compelling circumstance. That's the one where I have to make that decision, and it's an uncomfortable one.
It is.
So I just wanted to share that that's present. And that's why I just sort of kind of threw it out there, because I've had somebody, gainfully explain that they were confident in that. And I will wait for all proceedings to be over and done with before making any determination. But I let the appropriate parties make that determination.
Lonnie, there was a second question on that screen that you had about dating either a family member or a close relation or a close friend of a former client. I'm throwing that out there for the group. Is that a good idea or not a good idea? It's okay to date a family member of the former client or a close personal friend of the former client. Is that a good idea or not a good idea?
So good idea would be correct. Not a good idea would be incorrect.
You guys are quick learners. Yeah, that is correct. It would be a bad idea, because again, we go back to, if the family member or the close personal friend suddenly has a beef against the former client and they come to you because you're not their therapist, you're their partner, you're their boyfriend, their girlfriend, whatever the relationship happens to be, you are now put in the middle between a former client and a family member. Is
that happened? That actually happened with two brothers. We had a case.
So it does happen. It doesn't end well. It really just does not. So basically, if you haven't picked up on it yet, what we're saying here is please don't have a sexual relationship, a very close personal relationship with a client, with a former client. It's not going to end well.
Yeah, I mean, it's right up there with reheating food that's like 2 weeks old, just why bother?
Yeah, you worked too hard to get where you are. And the therapists that I have spoken to that had a moment and made that very poor choice are now regretting it horribly, because they're now facing the ones that I see are the licensing board complaints. They're trying to defend their actions to the board, and the board is saying, no. If you're lucky, you get suspension for, I think I saw one that came through maybe a couple of weeks ago. The person is suspended from practice for 2 years. And then when they go back in, they have to go back in under supervision. And they have to do all the CEUs. Plus, they have to keep up on all this stuff for that period of time when they can't practice. It's not a good idea.
Not worth it. No, no. Christina had a question. Christina, do you want to come on mic?
Hi, everybody. Thank you so much for this great presentation. I was just curious if you can share a little bit about how the ASI insurance packages differ from some of the other companies, since I know that this is specifically tailored to social workers. That was my first question. Then my other question, and I don't know if this is something that you can share, obviously with keeping confidentiality, but you've been sharing some pretty entertaining and eye-opening anecdotes. And I was wondering if you could share a little bit about anything that you've seen specifically in New Jersey. And Dina, I'm particularly interested in some of your experiences because you have a lot of experience with the licensing boards around the country. So curious if you can share a little bit about what you've seen, how the licensing board here in our state practices.
Yeah, I can handle the question about how we compare to other companies on this topic. I have to tell you that if you actually looked at the contracts of other carriers and ours, you'll see a lot of similarities. One thing that I have to let you know, and just because I oversee the process, I have my hands and fingers and can ensure that this is the way it works. So when you work with a large insurance company, they have underwriting guidelines, and their room for exceptions are very, very, very small, if not non-existent. When I use the term exceptions, meaning, remember that situation where I shared that I had to make a decision to non-renew because I had to protect certain things. We have something called an underwriting advocacy process, where if we yield a decision and it is felt by the professional that not all components were considered and that there was more information and they would like to appeal it, we have an appeals process, and that is something that no other company ever has. And I can assure you of that because I've worked with other companies in my past. So basically part of that process is to incorporate, well, hey, you made this decision based on A and B. I want to include C. And so I have reviewed and provided that feedback to a committee away from myself because I make a lot of underwriting decisions, and they transparently review it. And I have social workers on it and insurance professionals. So you have it viewed by peers, and it's confidential, that appeals process, and you have it viewed by an insurance professional as well. So I think that really speaks volumes that if there is a circumstance that definitely has a catch-22 in it or an unknown circumstance, and it's really important that be reconsidered, we do that. And in many cases, I can tell you that we actually have overturned our decision based on that new information.
As far as policy forms go, there is you talk about 25-page forms. There is some similarity in some areas. Other areas there's not, and I'm biased towards our policy that we cover some risks that are very technical, and other carriers exclude them. Other carriers might have a limit or a sublimit, but you really, I mean, to get to those answers, you really have to study and compare those policies, because there are some minute differences where I still believe that our policies, our GL and our cyber, and in particular our PLI, are more comprehensive than anybody else, and we don't have any deductibles, and I think we have the lowest premium. Medical malpractice and PLI rates have gone up astronomically in the last 2 years because of court cases and high claims. You asked about New Jersey. There was a claim we had. Keep this in mind, that the social worker was policyholder of ours, and she worked for as a contractor. I think it was for a state. I don't know whether it was the Bureau of Corrections or Health and Human Services, some New Jersey entity, and it involved a homeless person, and there were damages that arose from the homeless person that she was involved with, and she didn't do anything wrong, and so there was a lawsuit against the hospital or the system in question in New Jersey, and I think they got dismissed from the case because she was a contractor. They basically pushed the liability onto her, and had she not had a policy with us, she would have been in really big trouble. So that's the only thing, and that was several years ago. I think it was Orange County.
Christina, as far as the licensing board goes, New Jersey, to my recollection, is pretty much a little to zero tolerance for the actual misconduct. The allegations of misconduct, as we've said, the policy will defend you. We'll do everything we can to get it to get the complaint knocked down, but that takes time. And licensing boards didn't move at the speed of sound before COVID. And since COVID shut down and people are all working from home, they move slower.
The lawsuit example I gave you was not sexual misconduct or licensing board. It was a lawsuit for negligence against her. That was just the only case that I can think of that was in New Jersey that's top of mind.
Yeah. I followed up with a social or with an attorney in New Jersey over the weekend. As a matter of fact, I was going through checking up on files, and we've been waiting 2 years for a response to a board complaint.
Yeah.
So while you are sitting patiently waiting, knowing that you did nothing wrong, you've got this board complaint hanging over your head, which has to be disclosed as you renew your licensure, as you renew your insurance. You have to say, hey, I have this board complaint. I didn't do anything wrong, but I'm waiting for them to make up their minds. So it takes time, and it's nerve-wracking, and it's anxiety ridden. There's really nothing you can do but wait. So the New Jersey board, though, as I said, for sexual misconduct claims, generally they're not fond of them, and they're not going to end well.
Thank you so much for that information. Helen lost her internet, so I'm just going to wrap us up for the day. We are approaching 1 o'clock, and in the interest of people's times and calendars, we do want to end promptly. So thank you again for all this great information, really useful information. And just a reminder that this is the first of a 4-part series we're doing with the folks at the Risk Retention Group. So join us again, I believe, next week for the second installment. I can tell you really quickly for sure when that is. Our next one is, yes, next Tuesday, October 26th, defining and communicating boundaries in your relationships. And you can find the registration information for that on our website, NASWNJ.org. So thanks again, everybody, for being here. And hopefully we'll see you at the next one of these presentations. Have a great day, everyone.
Jeffrey, I went ahead and put my email address out there in case anybody has any follow-up questions.
Great. Thanks so much.
Thanks, everybody.
Bye.